Lawyers for Kelsey Fitzsimmons, a Northover police officer charged after being shot by a co-worker in June, are seeking the release of their client from custody by the state's highest court. Kelsey is accused of pointing a gun at a fellow officer who was delivering a restraining order issued by her fiancé during what officials have termed as an armed confrontation. Fitzsimmons denies making such an attempt and asserts that she was attempting to take her own life, facing the prospect of being separated from her son. A grand jury found no evidence that she intended to kill the officer and only indicted her on the charge of assault and battery with a dangerous weapon. Last month, a judge granted Kelsey's release under various conditions. However, she later reversed her decision and sent Kelsey back to jail after she complained of pain due to her injuries during court-mandated alcohol testing. In their appeal to the state Supreme Judicial Court, Kelsey's lawyer criticized Judge Kathleen Naiman's decision to revoke Kelsey's bail. During the September 11th hearing, Kelsey and her lawyers faced hostility, interruptions, skepticism from the judge, and a lack of consideration for alternative testing methods. The situation escalated to the point where the judge eventually left the bench in the middle of the argument. The hearing was convened after Kelsey's lawyer Tim Bradle and Martha Coakley filed a motion seeking relief from court-mandated scram testing. This testing required Kelsey to blow into a device to detect alcohol. However, Kelsey was unable to perform the test without experiencing significant pain due to her gunshot injuries. The probation officer assigned to her case documented Kelsey's pain while attempting to complete the testing. The filing requests that Kelsey's release be granted without a finding that she poses a danger. Additionally, the case should be sent back to Essex Superior Court with a different judge. A probation officer suggested that she could undergo urine testing at a facility near her parents' home where she was released. However, the judge dismissed the possibility of testing outside the home, stating in an order that she aimed to create conditions that minimize Kelsey's time outside home confinement. The filing asserts that there are alternatives to incarceration for Kelsey, which were inexplicably overlooked by the trial court. Essex County prosecutors have not responded to the appeal. During the hearing, the prosecutor handling Kelsey's case did not take a stance on the alcohol testing issue. The prosecution's position was simply that Kelsey continued to undergo alcohol testing, not that she must use a scram device. The appeal is assigned to Justice Elizabeth Dewar. She has not yet released a ruling, and Kelsey is scheduled to appear in court on October 7th for a pretrial hearing. An evidentiary hearing on a restraining order was initially set for September 23rd, but was postponed to November at the request of the attorneys. Don't forget, give me a follow. Let me know what you're thinking in the comments below. This case is kind of crazy. I still can't believe the judge revoked her bail like that.